This was a pretty big week for Supreme Court cases, so I wanted to discuss one other case that I think is very significant. That case is West Virginia versus BPJ. This was a case involving laws passed by West Virginia and Idaho that explicitly banned transgender girls from participating in girl sports. The petitioners argue that this is a straightforward violation of Title IX of the Civil Rights Act, as well as a straightforward equal protection issue. The Constitution guarantees the equal protection of the laws, and this is not equal protection. In fact, in both cases, this is the states singling out specific groups of people for the sake of imposing a stigma, of saying that these people do not belong. In a 6-3 decision written by Brett Kavanaugh, the Supreme Court disagreed and said that this wasn't an equal protection question and this wasn't a violation of Title IX. Kavanaugh said that because of the importance of sports, he talks a lot about coaching girls' sports, West Virginia and Idaho have a legitimate interest in maintaining the integrity of those sports. They have a legitimate interest in making sure that players are safe and can enjoy fair competition. And although the Constitution requires moderate scrutiny for any law that purports to treat people of different sexes or genders differently, Kavanaugh says the Constitution permits states to recognize sex distinctions. That's why girls' sports and boys' sports are legal in the first place. Now, in her dissent, in addition to making it clear that this is a clear violation of equal protection, Justice Sonia Sotomayor also notes that the states of West Virginia and Idaho are making specific claims, factual claims, claims about the athletic abilities and potential for harm that may come from transgender girls playing in girls' sports. And so Sotomayor said that we should return this back to the lower courts for fact-finding. Because if they're making factual claims, how we decide is going to be structured by the truth of those claims. But Kavanaugh and the majority say, we don't care about the facts. Now, the thing about this ruling, and the thing about the majority not caring about the facts, is that if you cared about the facts, you would notice that neither West Virginia nor Idaho seems actually all that interested in protecting girls' sports in any way, other than banning transgender girls from participation. You might notice that legislators in both states put forth these bans, not in terms of protecting sports, but in terms of opposing gender ideology, and in enforcing, not recognizing, but enforcing the performance of traditional gender identities. That's the point of these laws, not to say that we're going to try to protect girls, but to say that this particular gender expression is illegitimate, and thus we're going to punish it with state power. Now, that seems like a straightforward violation of the Civil Rights Act, especially after Justice Gorsuch's opinion a few years ago in Bostock, which incorporated gender identity into the Civil Rights Act's protections against sex discrimination. And worse, by the court taking a blind eye to the fact that these laws were about enforcing a particular vision of how people ought to act, the court also undermines long-standing doctrine about the fact that states and the federal government, for that matter, are actually not permitted to force people to perform gender identity in a particular way. You can't be forced to act like a man or act like a woman. But then I think the court's decision is less about the law here and more about its own antipathy to trans rights, its own antipathy to transgender people. Because you'll note that last year, in a case called Salazar v. Childs concerning conversion therapy, the court disregarded all of Colorado's fact-finding with regards to the fact that conversion therapy is harmful to children, disregarded the fact-finding with regards to the fact that gender-affirming care saves lives, said it doesn't matter, and instead said that it was unconstitutional on a First Amendment basis to outlaw conversion therapy. Whenever you give this court, this majority, an opportunity to decide on the rights of transgender people, this court says, not so much, and looks to restrict them, to limit them, to essentially say that these people don't have rights worth respecting, and that if states want to behave in a cruel manner towards them, they have every right to do so. Two thoughts. What the court has done is free states to just police gender identity in general. And we know who will be the targets of that policing. Any young woman who does not appear to conform to traditional notions of what womanhood looks like. They have short hair, they're muscular, whatnot. And I'll say, black women, black girls. They are the ones who, in addition to transgender girls, will be the primary victims, the primary targets of these laws. It is already the case that we have cultural narratives, prejudices against Black women being insufficiently feminine. Just a few weeks ago, we had a UFC chud call Michelle Obama a man, a popular insult on the political right, and an insult tied entirely to the idea that Black women are less feminine than white women. What I think is going to happen, basically, is that under these laws, it's now that they're allowed to stand, if a Black girl beats a white girl in a basketball game or a softball game or wherever, some angry parent may then use that law to say, we got to test to see if she's really a girl. And this is already happening, like I said. This kind of suspicion and scrutiny of women and girls who do not fit a particular white supremacist vision of femininity, they're already subject to this. And the court has basically said, let it rip. The second thing I'll say is that you can connect this decision to the court's decision in Mullen v. TPS. That's the case involving temporary protected status. We've discussed it before, where the court ignored the president's record of racist rhetoric towards Haitians in particular, and said that the administration could revoke temporary protected status without going through the statutory process, and that claims of racial discrimination, which should trigger an equal protection remedy, just don't apply here. In both cases, what the court is saying is that if you want to exhibit cruelty towards people deemed subordinate, towards people deemed less than, towards people who have been placed outside the circle of protection, then we're not going to stop you. Maybe because we agree. But the president can act in a cruel manner towards refugees, and states can act in a cruel manner towards transgender people. And I would say that the celebration of cruelty, the institutionalization of cruelty, is the primary ideological aim of whatever you want to call this political movement, Trumpism, MAGA, what have you. You see it in the birthright case. Ripping citizenship from people would be cruel, but 4 members say you can do it. It's a celebration of cruelty. It's the institutionalization of cruelty, of inflicting pain on people because you've decided that they do not belong to the political community any longer. There's a wonderful and influential book of political theory by the late theorist Judith Sklar called The Liberalism of Fear, in which Sklar argues for is a kind of minimalist liberalism, centered not on individual flourishing, centered not on pluralism, centered not on any of the things that we're familiar with in the liberal tradition, but centered on the avoidance of cruelty, on the avoidance of forms of government and governance that inflict pain on people for its own sake. A liberalism devoted to protecting people from cruelty and arbitrary pain and arbitrary force. It has a lot in common, I'd say, actually, with the neo-republicanism that emerged in the 1990s. And I think Sklar is very much in conversation with that. But I think there's a lot to learn from that and take from that in the present. As Sklar notes, we all fear cruelty, fear the imposition of pain, of the helplessness it produces. We dread it. It frightens us, and we'll do anything to avoid it. If one force in our politics right now is a celebration of cruelty, then I think the other opposing force must be a politics based on stopping cruelty wherever it exists. That has, I think, a lot of implications for institutions, for how you structure them, for the kind of rules you impose on public officials. But I think one big implication it has is that it cannot tolerate anything like we see in West Virginia v. BBJ. It cannot tolerate anything like we see in Mullen v. TPS. It cannot tolerate a government that allows for the imposition of cruelty. And whatever your larger political commitments, I think a lot of us can sign on to a political project that at its very foundation says we are not going to be cruel to each other.